harassment, but it's still relevant for this reason. On this 2002 work computer, the defendant had an extensive collection of pornographic images.
Judge, I object at this point, and I'd ask for a sidebar.
A lot of interesting pictures that were found on the hard drive, and
Well, sexual nature.
yeah. Oh yeah.
You sound like you've seen them, Chandler.
So Dali and I have been talking about this a lot, and because he's like very invested in this case, and he has way more knowledge than I do, but not to spoil anything, but this guy was obsessed with dick pics, and we will get to find out a little more about that. He collected a lot of interesting images.
Images of pornography, unless they can somehow be connected to the images that were dropped around the house or around the work. I'm not sure how that's relevant.
Well, it's the funniest part of the trial.
I think it's outrageous that Ms. McNeil's opening statement was interrupted by this. Defense counsel has known for years that this evidence had been admitted at the last trial. If it was defense counsel's intention to bring a motion to exclude this evidence, that motion should have been heard by this court. We had numerous pretrial motions. There's never been any question that this evidence was going to be admitted during the course of this trial. And this evidence is clearly critically relevant to the evidence the state is going to be presenting during the course of this case. These 2,200 penis photos that were on the defendant's computer demonstrate a number of things. It demonstrates his odd preoccupation with the male member.
Penis photos
demonstrates that his level of offense that he took, that his wife, Julie, had this affair with this Perry Tariqa, in which she had apparently performed fellatio upon Perry Tariqa, but it was something that she wouldn't do with him. These Venus photos that were left around the house for years and years and years, according to the investigating officers, including a detective Ellis, who was a private detective in this matter, reflected that somebody had an enormous array of pornography that they could tap in order to find penis photos that included a person that kind of looked like Julie, and included a background where they could not exclude her bedroom as being the place where these photos were taken. There was ample testimony about this at the last trial. The relevance of the other act's evidence has already been ruled upon by the Wisconsin Court of Appeals, and it's the law of the case in this matter.
Yeah.
So to interrupt this opening statement on this basis is outrageous, and the objection should be overruled, and we should continue with this opening statement.
2,200 penis photos.
You have a right, but it's not a good objection. I want it noted for the record. Bring the jury back.
Yeah, so that was a patently absurd. What's that?
I didn't expect all this.
What were you not expecting? I guess that was a surprise. All of the penis pictures that they have mentioned.
Penis? I did not.
Oh, you didn't know? Yeah.
No. So when you were saying about pornographic stuff and with Sal and everyone was saying about it, I was expecting like boobies or vaginas, not dicks.
Yeah, that's and he organized them by size also. That's my favorite part. There were a lot of them, and they were. Yeah, he was very, very organized. I don't know exactly why. I feel like my theory is that he had a fixation that, she had an affair with this guy because he was more well endowed and he was insecure about his size. But I don't really know yet. I'm curious to see how this all evolves. That was just a really interesting interaction because this objection doesn't make any sense considering there were pretrial motions that ruled on the admissibility of this evidence. If the evidence is in discovery, it is completely fair game. And so for prosecution, for the objection to come in, it's just absolutely patently absurd. It makes no sense.
That's part of the harassment. Here's the email. You'll see that it's from someone by the name of Turtle. That's the name in the email, to Mark Jensen. And then you'll see in the text of the email, consistent with the harassment, here's a few for Jay, so Julie, of me soft. Also a shot I took without her knowing it of the married girl in the office I'm currently doing at a nearby hotel. Attached to this email are 3 pornographic images of nude males, and then what looks like a surreptitious image taken of a topless woman in a hotel room. And it's consistent with the harassment because here's this harasser suggesting essentially he's doing it to another woman, taking pictures of her secretly, which was the same implication given to Julie Jensen in the course of this harassment. And then also, again, of course, the pictures of a nude male. This email is from M. Jensen at execpc.com to M. Jensen at execpc.com.
Yeah.
With the
That's what I thought.
names changed.
Real
So the way
genius.
you would see this email in 1998, it would just look like it's from an anonymous person named Turtle to Mark Jensen. But the way our computer analysts can see the email, our computer analysts can see who it's from. It's an
Wow.
email the
Hilarious.
defendant sent to himself, pretending under disguise to be, he's acting as the perpetrator of this harassment.
Oh my God.
So how do we know Mark Jensen is really the harasser? A variety of things, but this email proves it. Where else do we see the email?
Ooh, don't talk to Rumble. Is there anyone?
We're in recess.
An evidentiary matter outside the presence of the jury. That's the reason that we needed the recess, was so that the jury would be excused, so we could have this legal discussion outside the presence of the jury.
What are we going to argue about?
The issue is the court's ruling on the admissibility of the ability to have this witness testify about prior testimony or admit the prior testimony of this witness.
I denied it.
I know you did, and you
Bringing
denied
the
it,
jury back.
Judge. You denied it, but you didn't allow the state to make its argument. So,
Your counsel made her argument.
Your Honor, you denied
Your
it.
counsel made your argument. Bring the jury back.
Your Honor, it's prior testimony. It's not being offered to refresh a recollection. It's prior testimony. It's admissible under 908.045 of the Wisconsin statutes. This witness is unavailable on that particular issue. We deserve to be heard on this, Your Honor. It's a first-degree murder case. We should be following the rules of evidence. The rules of evidence indicate this testimony is admissible, and it's an important part of this case.
The jury probably could hear you yelling.
Well, Your Honor, please, the state is entitled to make an
Make
argument
your record.
on evidentiary issues.
Go ahead, make your record.
Under 908.045 with stats, subparagraph, under 908.04, a witness is deemed to be unavailable if she testifies to a lack of memory on the subject matter of the declarant's statement. That is what this witness testified to. She does not remember this statement. She said looking at the statement would not refresh her recollection. So it's not available to refresh her recollection. However, she's an unavailable witness as defined by section 908.04 on this particular issue. And then when you look at 908.045, subparagraph 1, former testimony, the following are not excluded by the hearsay rule if the declarant is unavailable as a witness. Paragraph 1, former testimony, testimony given as a witness at another hearing of the same or a different proceeding at the instance of or against a party with an opportunity to develop the testimony by direct, cross, or redirect examination with motive and interest similar to those of the party whom now offered. That is exactly what we have here. It's her prior testimony on an issue that she's now said she no longer recalls. Therefore, her prior testimony is admissible in this proceeding under 908.045, subparagraph 1.
Incredible, Sal. Incredible.
I think
Please don't yell at me.
I won't judge. I think the issue is that they were attempting to refresh this witness's memory, and she advised everyone that that would not help. That's